Hello and welcome. My name is Leslie Mendoza, and I'm an attorney at Tzedek Legal Services. Tzedek is a nonprofit organization, and we provide free legal services. My team handles guardianships, and we also assist and accompany minors who live with family members or caregivers who are not their parents. Tzedek also handles different types of cases, and at the end, we will provide the website so you can check out our website and see if there's anything that you may need help with. But today, we will be presenting about family preparedness. These are very difficult times for families, and we want to provide information so that families prepare and plan in action. You decide what to do with your family, and we're going to provide you some options today. Today, our topic is helping immigrant families prepare for their children's future under the Trump administration. Our presentation goals are the following: to provide you with necessary information and tools to help families plan for the future of their children. Also to debunk common misinformation, and we will go over some materials such as the Caregiver Affidavit and the Tzedek toolkit. We will discuss what the material has in later time during this presentation, and we will also again give you the website of our organization so that you can go and print out this information. Why are we doing this presentation? With the current immigration climate under the Trump administration, many families with mixed immigration statuses are faced with the harsh reality that they could be torn apart. Immigrant parents who enter the United States without permission or who are believed to have committed a crime are more susceptible to being detained and or deported. So what can you do to secure your child's safety and stability in your absence? The presentation goals are to offer options on how to best prepare yourself and your family in case of an emergency related to being detained or removed from the United States. You want to start off with communication. This is a conversation you want to have with the entire family and those who you want to take care of your child if anything happens to you, if you are detained or removed from the United States. Parents should speak to their children, friends, and family and come to an agreement about who should be the caretaker for their children in the event of detention or removal from the United States. Again, we understand that these are very difficult times and these are difficult conversations to have. But parents have to have a plan of action. So what is a plan of action? Well, first you keep important documents for each child in a folder and alert friends and family members as to the location of such folder. You also keep a list of important contact information for the child in such folder. Again, I will show you the Tzedek toolkit later on, and you can also use the Immigrant Legal Resource Center's toolkit as sample list of what you need to gather. The Tzedek created a toolkit for your review, and you can save that with all the information. We will again look at that toolkit later on, and also you can also use trusted organizations such as Immigrant Legal Resource Center, which provides a different toolkit, very similar to Tzedek. So you can use either toolkit to help yourself get prepared. These are hard decisions and hard conversations, but it is important that everyone is aware of your plans. And if you have kids, that you plan ahead. If anything, it can provide some peace of mind if you are detained or removed from the United States. The decisions that parents need to take are different. Does the parent want the children to reunite with them abroad in the future? Do you want the family to be torn apart? Or do you want And do you have anyone willing or able to care for the child for an extended period of time? Are the children very young? Or does the parent prefer to have their children stay in the United States? Does the child have special needs and more access to health and community resources in the United States? Is the child old enough to make or verbalize unwillingness to move to another country? Does the child have more opportunities to an education and other resources here in the United States? Again, these are different thoughts for different families and different choices. Another consideration is finding a caregiver. Regardless, the child will most likely be without a parent for a period of time, and the parent should decide who will take care of his or her child during that time. You want to identify the person or persons and make sure that they know that you have designated them. There are two types of caregivers. One is informal caregivers, and two are legal guardians. And I will discuss more what each entails in a bit. Informal caregivers are those who have assumed responsibility for a child in need without involvement from the court system, child protective services, or other authorities. You may have physical custody of the child, but have limited rights to making decisions regarding a child in their care because they don't have legal custody. While legal guardianships is a legal process where an informal caregiver files a petition with the probate court to ask for legal custody of a child. It does not terminate the child's parents' rights, rather, it suspends a parent's rights at that time temporarily. Many parents are reluctant to fathom the idea of giving up custody rights over their children. Now, how many of you have heard of parents paying for power of attorneys or notarized letters granting a non-parent custody of a child in the event a parent gets deported? This happens often, and it really doesn't work. We want to inform you to avoid notario fraud. The immigrant population is especially susceptible to notario fraud. Many individuals have been advised to draft a power of attorney or notarized letter giving temporary legal custody of their children to an individual in the event of deportation. These letters cost money, up to $200 or more. Custody of a minor can only be legally transferred from one parent to a non-parent via a court order. It's important to know that in California, notarized letters and power of attorneys have no legal validity in terms of the transfer of custody of children and should not be used as part of family preparedness. Again, do not use power of attorneys to transfer the custody of a child to a person who's not their parent. It will not work in California. Maybe in different states, but not in California. I also want to advise you that at this time, you should look into talking to someone about your immigration case. And again, avoid notarios. Verify that the attorney is in good standing and is able to practice law or speak to a Department of Justice accredited representative. I can provide these links so that you can check whether an attorney is in good standing and search for their name. And you can also verify whether the Department of Justice accredited representative is on the list of accredited representatives. These are two links that are useful for you to use to make sure that whoever you're speaking to is able to practice law in California if they're an attorney or that they're a accredited representative. Now let's talk a little bit more about the caregiver affidavit. If a parent is reluctant to have their parental rights suspended, they can complete a caregiver's affidavit. This affidavit identifies the individual whom they authorize to make decisions regarding the child. These are limited decisions regarding education and medical care, such as immunization. The information on what the caregiver affidavit allows is found on the backside of the caregiver affidavit. You can access the caregiver affidavit on Tzedek's website, which I will provide at the end. The caregiver affidavit allows the person who signs the form to enroll the child in school. It also identifies a qualified caregiver, such as a grandparent, siblings, an aunt, an uncle, even if they have been now divorced. Unrelated caregivers can only authorize school-related medical care, such as a physical exam or vaccinations for enrollment. All of this information is provided on the caregiver affidavit. Now let's take a look at the caregiver affidavit. This is a sample of the caregiver affidavit. If needed, an informal caregiver can sign the caregiver affidavit. This should only be signed once it is needed by the caregiver and not the parent. Again, it allows them to make limited decisions regarding education and medical care for the child. It is verifying that the child lives with this person. The caregiver affidavit is a document based on Division 11 of the California Family Code. The document is to be signed by the intended caregiver and not the parent. We also recommend that the caregiver does not sign it until it is needed. And we recommend that it be kept unsigned by the parent until you need it. And the document does not need to be notarized. I want to note that the caregiver affidavit does not expire, but the caregiver must update with a new address or notify the school or medical office which it has given this piece of paper if the child moves or returns to the parent. In fact, on the form it says if the minor stops living with you, you are required to notify any school, healthcare provider, or healthcare service plan to which you have given this affidavit. Again, all the information that is needed and required is on the form for the caregiver to review and understand. Now, when is a notarized letter appropriate? Well, many parents want to know how they can ensure their child can travel to the parent's home country without one or both parents being on the plane. Parents, we suggest, will need to contact the airline and home country's consulate to see what documents they need to allow the child to board the plane without them. This may include the need of a very specific notarized letter signed by the parent granting the child permission to travel alone or accompanied by a non-parent. Again, this information is for those parents who wish that their child be reunited with them in their home country. We definitely suggest that you contact the airline or the consulate to get more detailed information, as they all are different. And you want to know how you can get your child to you safely and what documents you will need. Again, the notarized letter here is for that specific purpose, so that the child can travel without the parent. But we remind you not to use notarized letters to transfer custody of the child, as I explained before. If the child is to stay in the United States, if a parent wishes that their child remain in the United States and not be reunited with the parent in the parent's home country, the parent should seriously consider a potential legal guardian for their child. Now, consider someone you trust, someone that you are comfortable with making decisions about your child's health and and education, and even where your child will live. What are the rights of a guardian? A legal guardian has the ability to act on the child's behalf and make decisions regarding the child as if the guardian were actually the child's parent. If a caregiver files a legal guardianship and it is granted, the caregiver steps into the shoes of a parent as a legal guardian. So now let's discuss the differences between an informal caregiver and legal guardianship. For informal custody or caregivers, parents have full rights, including the right to reclaim the child at any time. If an informal caregiver, say someone who you allow the child to remain in case you are detained, and they sign the caregiver affidavit, once you get out of detention, you can come and reclaim your child, even if the caregiver has signed that affidavit, caregiver affidavit. Again, the caregiver affidavit would have to be withdrawn from the school or medical office which the caregiver has given and notify them that they are returned with their parents. On the other hand, a legal guardianship, the parents' rights are suspended and transferred temporarily to a legal guardian. The parent must go to the court to terminate the legal guardianship before reclaiming the child. Therefore, it is extra steps and is only for the benefit of the child to ensure that whoever's taking care of the child has the legal guardianship and is allowed to take care of them. And if the parent wants to reclaim the child for any reason, they go back to court and ask the court to terminate that legal guardianship. In an informal custody or informal caregiver, the child's ineligible for caregiver's work insurance plan. While in a legal guardianship, the child is eligible for caregiver's work insurance plans. Something to consider. In an informal custody, the caregivers can consent if a parent or legal guardian's consent is required. However, in a legal guardianship, the legal guardian is able to give consent. In both cases, an informal custody or a legal guardianship, in both scenarios, the parents have the responsibility to financially support the child. So it's very important that you consider whether you are going to leave your child and if that person can take care of your child, if they have the means to take care of them, if you're not able to send them money quickly. You can also start saving money to leave some money behind. But again, the parents have the responsibility to financially support the child. So looking for a caregiver that may be able to take care of a child without the need of monetary support from the parent quickly is something that you may consider. What benefits are available to the child? Children being raised by a caregiver or legal guardian may be eligible for monthly cash assistance from CalWorks, health insurance through Medi-Cal, SSI, where the child has a disability, or survivorship benefits. Again, these benefits are available to the child if they are eligible. So if they're eligible before, they're still eligible whether they're being taken care of by a caregiver or a legal guardian. Now let's distinguish a legal guardianship versus an adoption. In a legal guardianship, the parent's rights are temporarily suspended, whereas in an adoption, they permanently terminate the parent's rights. It is very different. When you're doing a legal guardianship, you're just suspending the parent's rights. Let's distinguish a caregiver affidavit. The caregiver affidavit and a legal guardianship. In a legal guardianship provides the rights to care, custody, and control of the minor. Again, in a legal guardianship, the caregiver steps into the shoes of the parent and is able to take care have legal custody and control of the minor, make those decisions for the minor. Whereas a caregiver affidavit only has the power to enroll the minor in school and authorize medical care. It is very limited. Now let's talk about the guardian considerations. Who should take care of your child? The caretaker should be over 18. The caretaker does not need to have lawful status, him or herself. However, at this time, given the administration's anti-immigrant, it might be better to find someone who does have lawful status, or perhaps two options. But again, the caregiver does not need to have lawful status. This caregiver does not need to be a family member. If you feel comfortable enough or are very close to someone who you see as a family but is not related to you, they can also be considered as the caregiver or legal guardian. The caretaker must be willing to be responsible for the child until they turn 18. That's for the legal guardianship. For someone to take care of your child and file a legal guardianship, they must know that they would be responsible up until the child's 18th birthday, unless the parent comes and requests to terminate the legal guardianship before then. The caretaker will need to undergo an investigation by the probate court if it's a family member, or the Department of Children and Family Services if it's not a family member and it's not related to the minor. If you have a child who's over 18 and are able and willing to watch over the younger sibling, this is another potential consideration. Again, these considerations for legal guardianships are more detailed. As I said before, the caregiver affidavit gives limited power. But if someone wants to be a legal guardian, then they need to understand that they will go through different steps. And the caregiver will go through an investigation by the probate court if they're a family member, or the Department of Children and Family Services if it's not a family member. We're telling you this so that you can give this information to the potential person you're considering that may be a legal guardian for your child. So you can have all the information that they may want to know. And so they're well prepared and ready if they want to file the legal guardianship. A parent also has the choice of nominating a guardian. You can find this form on the California State Court's website where you nominate a guardian. You indicate that you are the parent and that you nominate and include the name and address as the guardian of the person. If you need help filling out this section, you can call Tzedek office and we will provide that information later on. However, the link there provides you the quick access to this form so that you can fill it out and provide, as I said, the name and address of the person that you want to nominate as the legal guardian. And you can save this form with all your other documents and important information. Now, before I go on, this nomination is considered by the court and can be used by the person who would want to file a legal guardianship. They can take it and put it together with all the other documents and provide it to the court. The court will then consider and take this into consideration. Now, we also want to inform you of the notice requirements for a guardianship. Personal service at least 15 days prior to the hearing to the child who is subject to the proceedings if he's over the age of 12, the child's parents, the proposed guardian, or the child's legal custodian, if there's any. And male service at least 15 days prior to the hearing to the paternal and maternal grandparents, siblings or half-siblings who are over the age of 12, persons presently having the care of the minor, and for those who are not related to the minor who are the proposed guardians and are not related to the minor will have to give notice to the Department of Children and Family Services and the California Department of Social Services. Again, for those last two, notice is needed for this agency only if the petitioner is not related to the minor. That is, the person who wants to be the legal guardian is not related to the minor. There are two exceptions to notice. One is if providing notice would be contrary to the interest of justice, or two, if individual cannot be reasonably with diligence be given notice, if someone cannot be found. Again, this is information for you to consider and provide to the person who will be taking care of your child so that you can then give them all the information they will need, or if they're not going to be able to find someone, and they can give that information if they hire an attorney or look for an attorney, or provide it themselves if they fill out the forms alone. So what is the guardianship timeline? First, the proposed guardian will fill out and sign the petitions and all the forms that are related to the legal guardianship. Then they file the petition and all the forms related to filing a guardianship. They then attend a hearing for the appointment of a temporary guardian if necessary, and then after, they have the probate investigation or case review conference. They are to provide notice to the people who they know where they live, or create a declaration of due diligence for those that they cannot give notice to. They then attend a hearing for appointment of a guardian. And at the hearing, the judge will decide whether they will grant the guardianship or not. If they grant the guardianship, then they will then file what are called the letters of guardianship. The letters of guardianship are stamped and sealed by the court. It is also provided with the orders of guardianship. These two documents are the documents that the legal guardian must show to show that they are allowed to exercise the rights and have legal custody over the child and are the legal guardians. Again, remind whoever is going to be taking care of your child that if they file a legal guardianship, they will go through a probate investigation. Now, this isn't bad. This is just to make sure that your child is being taken care of, that the person understands their role, and that the child feels comfortable being with this person. They also will ask some personal questions and have a confidential form that the proposed guardian will have to fill out. The court wants to know whether this person has had any criminal history that may affect their ability to be a guardian. Again, these are crimes related to child abuse or alcohol and drugs. And so it is important that they do this to make sure that the child is being taken care of correctly and that they're in a safe home. So it's not a bad thing. It does create an additional step. It is important that we all want that the probate investigator or the Department of Children's Services to conduct these investigations to make sure that the child is going to be taken care of properly and safely. So again, the probate investigation. The investigation of the proposed guardian's home and background. There are two types of investigation depending on the relationship between the child and the proposed guardian. Again, if the proposed guardian is a relative, the probate investigator will conduct that investigation, which is the court where you file your documents. If the proposed guardian is a non-relative, then the Department of Children and Family Services social worker will conduct that investigation. Attending the hearing for guardianship. The children or child and the petitioner or petitioners must attend the hearing. After the hearing, if it is granted, they will file the order appointing the guardian of the minor and the letters of guardianship. Again, the case is complete once the guardian, if it is granted, gets the orders appointing the guardian of minor and the letters of guardianship issued by the court. this, again, is information for you to take and provide to the potential caregiver or the potential legal guardian that you're considering for your child. Discuss these steps with them so they are well prepared and aren't surprised when they're told that there's an investigation, that they have to attend a hearing, etc. Now let's talk about the Tzedek Family Preparedness Toolkit. You can find this toolkit on Tzedek's website. You can also find a very similar toolkit provided by ILRC, and you can look on their website to get that document and information. Again, we suggest to you that if you're undocumented or have a mixed family, you go and seek a consultation with an attorney about your case. Make sure that it is an attorney in good standing or an accredited representative. And then use this toolkit to prepare in case of an emergency. The toolkit will provide you a list of documents that you will need to put aside in case of an emergency. It will also go over all the information that I've just given about what is an informal caregiver and a legal guardian. The differences that I just reviewed will be on this toolkit for your review. This is another part of the page of the toolkit. You can print this out and use this booklet to fill out the information and save it with the rest of the document. What's important is to gather important documents right now, such as birth certificate, social securities, ID numbers, passports, and if you don't have passports, apply for them now and get those ready, especially if a parent is intending that their child reunite with them in their home country in case the parent is removed from the United States. Make sure you start preparing by getting that passport now or renewing if you have it, and it will be expiring soon. Also include health insurance, medications that your child takes if there's any, school contacts, or teachers. And one important step is that you update the emergency contact at school right now. If there's a restraining order, make sure that you make a copy of that restraining order, especially if it includes the minor. Make a list of the doctor, therapist, or anyone else your child sees, and that the person who's going to take care of them will know so that they can also call and make appointments. We also suggest that you and the minor memorize the intended caregiver's phone number. After having a discussion with your family and decide who will be the person taking care of your child in case of an emergency, then you all have that information, the name, the address, and the phone number. This will make it easier for a child to verify the information if he is taken from the school and placed with the Department of Children and Family Services if no one picks them up. They can then say, I am going to go live with this person, as my parent has suggested, and they will contact that person. You can also include a copy of the caregiver affidavit in all your documents that you're saving in case of an emergency. You can fill it out as much as you want and even include the name of the caregiver. But again, don't sign it because that is signed only by the caregiver when it is needed. You can also print out and include a copy of the GC 211 nomination of the guardian. And that form you do sign and you add the name and address of the person you want to be the guardian or nominate as the guardian for your child. Set up your caregiver to effectively and safely care for your child by filling out all this information. Now, if you have any questions related to this, we suggest that you provide the information to the proposed legal guardian or the person you intend to be the caregiver, and let them know that if they have any questions in the future and need to file legal guardianship, that they contact our office. If you need help filling out the GC 211, you can contact our office. Again, Tzedek Legal Services provides free help to low-income individuals in preparing petitions for legal guardianships and will represent them in state court if they're eligible. The office phone number is as listed. And here is our website. Please use the website to get more information that may be useful to you. Again, we provide different types of services, and you can go online and do an intake if there's something else that we may be able to help you with. If your child's caregiver has any questions or needs help with legal guardianship, please ask the caregiver to call our team's paralegal, Angelica Rodriguez, at the number listed, or send her an email. Again, this information is to be used by the parents to provide this to the person who you want to take care of your child in case of an emergency. You don't have to do anything now. We don't have to fill out legal guardianships right now because you don't need them. You just want to make sure that you have the person ready in case of an emergency. And if they have any questions or want to prepare legal guardianship because the parent will be absent for a very long time, then they can call our office and we can help them set that up if they're eligible. Again, we provide free legal services to those that are eligible. Please check out our website. Remember to use trusted organizations such as the Immigrant Legal Resource Center and others, and use our website to check out all the other things that we have for family preparedness and different types of services that we may be able to provide to you. We understand that these are very difficult times. These are hard conversations, but we're here to help if you need any help. Thank you, and take care of yourself.